which is wonderful. I'm Tanya Penovich and I'm the Acting Director of the Castan Centre. And I'd like to start by acknowledging the people of the Kulin Nations on whose land we're gathered and pay my respects to their elders past and present. As many of you would know, the Castan Centre for Human Rights Law is a research centre based in the law faculty at Monash University. We seek to improve human rights through policy, public education and our student programs. It's a very busy time in Australia for human rights right at the moment. For example, the scourge of offshore processing remains a blight on our country's human rights record. A Royal Commission is preparing to hand down its findings into the disgraceful detention of mostly Indigenous youth in the Northern Territory. And of course, we are in the middle of a vital battle to recognise equality for all LGBTIQ people through amendments to the marriage law. But today we are here to talk about Australia on the international stage. This week, our human rights record will be scrutinised by the UN Human Rights Committee, an independent body that will focus on each of these issues and many more. And also this week, Australia will almost certainly be elected to a 3-year term on the UN Human Rights Council. That pending term, that very likely pending term, which will start next year, is the topic of today's lecture by a long-time friend of the Centre, Professor Hilary Charlesworth. I particularly want to thank King and Wood Mallesons for hosting this event and have every year for over a decade. I would like to now introduce Ben Kiley, Senior Associate at King and Wood Mallesons, who will introduce Hilary Charlesworth.
Thank you very much, Tanya, and welcome all on behalf of the partners of King and Wood Mallesons to this lecture, which promises to be a fascinating lecture on a very interesting topic. On behalf of the partners, I would also like to acknowledge the traditional owners of the land on which we meet, the Wurundjeri people of the Kulin Nation, and I pay on behalf of the partners our respect to their elders, past and present. King and Wood Mallesons is very proud to present today's lecture with the Castan Centre. As Tanya mentioned, we've had a long association with the Centre that we're very proud of, and for over 10 years we've jointly presented this annual lecture, which invites each year high-profile and leading public figures to share the latest thinking on human rights issues and matters. And this year promises to be no different at all. Mallesons is a top-tier global firm with over 2,000 lawyers in 26 locations globally. We're the only law firm that's able to practice in Chinese, Hong Kong, Australian, English and US law, and Mallesons is the first and only law firm based in Asia. In Australia, through our Human Rights and Community Program, we have a strong commitment to human rights. We're the only law firm in Australia that has a dedicated human rights law group, which allows our partners and lawyers to apply their market-leading insights to assist our commercial clients comply with their human rights obligations, as well as our community partners and pro bono clients to achieve justice in circumstances where they may not otherwise be able to. In the last financial year in Melbourne alone, Mallesons lawyers donated the equivalent of over $4.5 million worth of legal services to human rights and other worthy causes. But enough about us, on to the speaker for today's lecture. As has been mentioned, it's Professor Hilary Charlesworth. Professor Charlesworth is the Laureate Professor at Melbourne Law School and a Distinguished Professor at the ANU. She was educated at the University of Melbourne and at Harvard Law School, and has had a long and illustrious career in public international law. Throughout her career, Professor Charlesworth has been heavily involved in both academia and practice. Her current research topics include the structure of the international legal system, peace building, human rights law and international law theory, with a particular emphasis on feminist approaches to international law. She's a member of the Executive Council of the Asian Society for International Law and is the past president of the Australian and New Zealand Society for International Law. Professor Charlesworth has served as an ad hoc judge of the International Court of Justice in the whaling in the Antarctic Case between 2011 and 2014, and more recently she was appointed by the Australian Government in 2015 to a second term as a member of the Permanent Court of Arbitration. The topic of today's speech is what role can Australia play on the United Nations Human Rights Council? As Tanya mentioned, until recently, Australia's 2-year campaign for a seat on that council has been heavily contested, with both Spain and France competing for this position. However, with the recent withdrawal of these two competing candidates, Australia's election is now almost a certainty, barring any unforeseen circumstances happening in the next 24 hours, with voting taking place later today, New York time. This will apparently mark the first time that Australia has been a member of the Human Rights Council in the UN's history. As part of its campaign, Australia has made several pledges, possibly some of them non-core promises, to use Australian political lingo, including to hold a referendum on the constitutional recognition of Aboriginal and Torres Strait Islander peoples, to campaign against gender-based violence, and to advocate the protection of freedom of expression. Against this background, Hilary's topic today promises to be an especially timely address. And would you please warmly welcome Professor Hilary Charlesworth.
Many thanks to Tanya and Ben for those very kind introductions, and let me join both of them in acknowledging the traditional owners of the land on which we meet, the Wurundjeri people of the Kulin Nation. Well, I was really thrilled to be invited to give this lecture because it gives a chance to reflect on the rich legacy of Ron Castan, who of course gives his name to the centre, who was a very distinguished barrister and human rights advocate. I think today human rights lawyers are relatively thick on the ground, but Ron, I think it's worthwhile pausing just to remember he was really a pioneer in this field. I still recall the first time I saw him in action, which was when he was arguing in the High Court in the Antarctic Case back in 1982. He combined a fearlessness and doggedness in the face of what seemed to be a rather sceptical court. And I was really struck by the fact that he both had this incredible mastery of legal detail, but it was really infused with passion about the implications of that case, about the future, of course, of the Race Discrimination Act. I think watching Ron argue in that case really opened my eyes to the possibilities of bringing international standards to shape Australian law. But of course, Ron went on to work on some of the major human rights cases in Australia. Here he is with Eddie Mabo, and he also worked on the Wick cases. He had, of course, as is very well known, a big interest in Indigenous rights. But unlike many Australian lawyers, Ron kept a very close eye on the international arena. So he was concerned with acts of injustice wherever they occurred, and he paid special attention to what was going on in both Tibet and in East Timor. So I think that Ron would be really proud of the work that the centre that bears his name has done over the years. The Castan Centre has really been, in Australia and internationally, a hub of really creative research and engagement with human rights issues, and its work continues to be at the cutting edge of the field. As has been well foreshadowed, I plan to focus on the engine room of human rights activity within the UN system, which is the UN Human Rights Council. The council was established, has now over a decade of experience, to replace the much criticised Commission on Human Rights. And so it's quite a good time to think about what's it done, what's its future, is it of value? And also, as Ben has pointed out, Australia is a pretty sure bet tonight, our time, to be elected to the Human Rights Council. I didn't quite know the date of the election. I think nobody did till last week when I chose this topic. So I was very pleased that the UN has got wind of this talk and decided to put the election on today. So the Western Europe and Others group, the WEOG group, has 2 seats in this election. 15 members of the council are going to be elected tonight. And as has been pointed out by Ben, France withdrew its candidacy in July. Apparently, the politics behind that are quite interesting. Apparently, there was a bit of a fear by the new President Macron that the French may not win. And so the thought was to withdraw rather than to have what would be seen as the embarrassment of not being elected. So it'll be Spain and Australia. Spain, very interesting that it's going on to the Council in light of what's going on in Catalonia. So what I want to do is to think about, first of all, what does the Council do? What contribution can Australia make to the Council? And then, what impact can the Council have on Australia? Well, the UN Charter back in 1945 created the Commission on Human Rights. And this body, there's just a huge literature on what a disaster it was considered. It disappointed almost everyone, human rights activists as well as states. And by the new millennium, the Commission was widely derided and regarded as a tool used by states to mask their human rights abuses. So in 2005, when Kofi Annan, the then Secretary General, set up his agenda for reform, which was contained in his document, Enlarge Freedom, this is part of the document simply pointing out that he spoke about the declining credibility and professionalism of this body. Now that's pretty strong stuff coming from the Secretary General of the UN to talk about one of the charter bodies actually being such a disaster. But he made the point that was widely thought: states are on the Commission really just to bulletproof themselves against human rights criticism. And he spoke of this credibility deficit. So the Council then was established, and this is a picture. You can tell I'm a fairly amateurish user of PowerPoint because some of them are a bit blurry, so I do apologise. But this is the General Assembly in New York voting to establish the Council in 2006. And it was actually quite contentious, with the Americans in particular quite critical of the makeup of the Commission. But this was, the UN Human Rights Council is perhaps the signal, the flagship, if you like, the only thing that really got through of Kofi Annan's otherwise very ambitious reform agenda. One of the big debates was, should we confine the membership of the Council just to the human rights good guys? In other words, the Americans, for example, argued very strongly, look, we should only allow members to be elected to the Council if they have not been criticised for human rights abuses by the Security Council. Kofi Annan wanted a really small group of states, but in the end, neither of those proposals won through. And any state can be elected to the Council, and you simply need a bare majority of votes in the General Assembly. One of the other American proposals was by John Bolton, the then US ambassador to the UN, was to say you'd have to achieve 2/3 of General Assembly members. The idea would be that would whittle out some of the more outrageous candidacies, but that certainly didn't get through the General Assembly, which most of you will understand, where the West doesn't hold all the votes. So in the end, there are 47 members of the Human Rights Council, and this is a picture of the Council in action, and I draw your attention to the splendid ceiling donated by Spain. So Spain is now getting its reward by being surely elected tonight. This is by a Spanish artist, Juan Manuel Barroso, who, if you're sitting in that council chamber, it's rather extraordinary because it's very much a three-dimensional ceiling. But anyway, you'll see a few photos of the Commission. So it has 47 members. The old Commission had 53. So you can see there's not a huge difference in membership. The geographical distribution, and in true UN form, the seats are committed. Every regional bloc gets a number of seats, and the smaller number of seats has really increased the influence of the so-called like-minded group. This is a very important grouping in the work of the Human Rights Council. This is a coalition. Effectively, it's a group that defines themselves by being non-Western. So it includes both developed and developing countries, but some of the leading lights in the like-minded group include China, Russia, Arab states, African states, and members of the Organisation of Islamic Cooperation. What you find, and this is a bit broad brush, but not too unfair, is that this group tends to be overtly hostile to human rights scrutiny, often raising national sovereignty as a counterpoint to it. And it's particularly very much resists protection of human rights defenders. It usually tries to weaken protection for human rights defenders. But it's a complicated body. It's got 52 members, and there is a Likeminded Group charter adopted recently. At the moment, Egypt is chair of the Likeminded Group. Well, in many ways, sorry, I'll just leave it on that one for the moment. The Council mirrors the procedures that had already been on the go in the Commission on Human Rights. For example, one of the big things it does is to adopt normative standards in the field of human rights. It has an elaborate system of special rapporteurs, known as the special procedures. It has an expert advisory committee which replaces the old subcommission on the promotion and protection of human rights. The system of special procedures, a special rapporteur, is a notable feature of the Council. These are independent human rights experts appointed by the Council who report and advise on human rights issues. And there are currently 44 special rapporteurs covering a range of themes on an extraordinary range of topics, from albinism to violence against women, the rights of Indigenous peoples, to the human rights of older persons. And then there are another 15 special rapporteurs who deal with human rights situations in particular countries. At the moment, these include Cambodia, Myanmar, and Palestine. Well, I think overall these special procedures have contributed a great deal to the credibility of the Council by documenting human rights abuses and identifying ways forward. And this is a photo of an Australian. I didn't choose him just because he was Australian, but also I think he's an outstanding figure. Philip Alston, also a Melburnian. Philip has been the Special Rapporteur on summary and arbitrary executions, and he's currently the Special Rapporteur on extreme poverty and human rights. And I think Philip sort of exemplifies the very best of the Special Rapporteurs. He's been absolutely fearless. His reports make great reading because they don't have any of the standard UN blandness at all. They're extremely punchy. But I recommend for your reading, your bedtime reading, his letter to the UN. He's taken on the question of the UN's responsibility for bringing cholera to Haiti, and the fact that the UN has quite shamefully and shamelessly been trying to duck any responsibility for it. And he's exceptionally critical, Philip, of the Office of Legal Affairs, the UN's Office of Legal Affairs, not only criticising them, you might say excoriating the Office of Legal Affairs to avoid accountability for UN accountability for this epidemic in Haiti. The Council has also appointed various special commissions of inquiry to investigate serious human rights violations. A current one, for example, is Syria. While all of these commissions have produced pretty penetrating reports, it's been really hard to get the Council to act on them. So one example is a recent report from a special commission on massive human rights in Burundi, which has really failed at the moment to get any action from the Council. Burundi is a current member of the Human Rights Council, but the African bloc has come in to support them. So the Council, even though there's a certain irony after 10 years, we can see that the Council that was meant to fix all the problems of the old Commission, the Commission was criticised for having double standards with respect to human rights violations, and it's pretty easy to see that one could criticise the Council on exactly the same basis. Perhaps the high point of the Human Rights Council is a new mechanism that it introduced, which is known as the Universal Periodic Review. This is, I think, a very interesting feature of the Human Rights Council's work. What it does, by its name, you can tell Universal Periodic Review, it requires that all 193 member states of the UN must undergo a review of their human rights commitments and practices every 4.5 years. And the idea of having a universal review was to get away from the old Commission on Human Rights selectivity in a limited list of human rights abusing countries. So the idea is you would touch every country. And I think it's true now we've had 2 complete rounds of the Universal Periodic Review, embarking on the 3rd round. There are a few observations one can make about the success of the Universal Periodic Review. It's pretty clear that states take peer review, meaning the review is by member states rather than expert committees. So there's been reference made to Australia's appearance before the Human Rights Committee, which monitors the Covenant on Civil and Political Rights this week, you notice that a lot of countries tend to deride the human rights treaty bodies as a bunch of experts, but they're a bit more cautious about criticism from their peers, other states. I think the claimed universality of the Universal Periodic Review is symbolically significant. The fact that every member of the UN turns up. Israel has tried to postpone the hearing, but in the end it also turned up. And there is something very powerful if you see countries like China, Russia and the United States turning up and being put through their human rights paces. It seems to me that is something that is significant. And you can also point to things, the fact that China has blocked access to the webcasts of its Universal Periodic Review sessions. All of them are webcasts. And the fact that China has blocked them suggests that it is a powerful tool for civil society. And what we see is perhaps the Universal Periodic Review has been most useful to civil society groups in particular countries who've been very resourceful in picking up these recommendations to bring pressure for human rights protection at the national level. But it's also, I think, possible to see that states have pretty quickly learned techniques to blunt the potential of the Universal Periodic Review. And as I'll mention in a little while, countries like Australia and many other states often tend to engage in what I will call human rights ritualism, meaning accepting the Universal Periodic Review recommendations, but then accepting them in theory, but then completely failing to implement them. When we look at the normative standards that the Council has adopted, we can see both progressive and regressive moves. So the progressive side, over the past decade, the Council has adopted important new standards on issues such as enforced disappearances and on the right to water and on sanitation. But we can also see, so while there's certainly been some progress, we can also see deep currents of resistance within the Council. And these particularly involve issues of women's roles and issues of sexuality. And one example is a set of agenda items dealing what were called traditional values of humankind that have been the subject of a number of successful resolutions in the Council for a few years. So the idea is you have traditional values of human rights, traditional values of humankind on the one hand, and human rights on the other. So an attempt to actually pit traditional values against human rights. It reminds me a little bit of the move in Australia to pit common law rights sometimes against human rights. So this idea, we've just got an alternative category for you. So interestingly, the traditional values resolutions were, this is part of the debate on them, were a Russian initiative reflecting Russia's concern with its declining population and high rates of family breakdown. So Russian politicians have blamed these phenomena on both the women's rights and gay rights movements, and also in order to shore up support from the Russian Orthodox Church. So you found during between 2009 and 2013, there are a series of resolutions adopted by the Council that endorse traditional values of humankind, either in contradistinction to human rights or as the essential underpinning of human rights. And there were claims made in the debates that unless human rights were based on traditional values, they could not be considered valid. So this produced a lot of intense debates, but because the Likeminded Group essentially controlled the votes in the Council, you saw a series of resolutions adopted each year with quite then strong criticism. All of the Western Europe and Others group would vote against these resolutions, but they were always outvoted. So that was one interesting development. Civil society groups at the UN level, for example, the International Service for Human Rights, headed up, of course, by another Melbourneian, Phil Lynch, Hugh de Kretz's predecessor at the Human Rights Law Centre, were very, very active in criticising these moves. And in the end, they were very controversial and they were dropped. But they have appeared in another guise. this is quite interesting because now the attention of the Like-Minded Group has started up a new campaign with many of the same rationales, which is called Protection of the Family, the Protection of the Family Agenda. So there have been resolutions adopted on protection of the family each year since 2014, calling on states to adopt family-friendly laws and policies. So that might sound, well, what's wrong with that? That sounds surely it's something we might welcome. And it's only when one actually looks at the text of these resolutions you see that, to me, they are quite problematic. So first of all, there's an insistence that there's only one form of family. And there have been attempts by various countries to insert in these resolutions family can be understood as many different forms. But the form of the family recognised in the Human Rights Council resolutions is very much a heterosexual family. It does refer to women-headed heads of households, but they are considered to be widows. That's in that context. So there are extraordinarily narrow views of family, and as I say, a number of members of the Human Rights Council have tried to amend the resolutions to have a broader understanding of family inserted without any success. The Human Rights Council resolutions make constant references to what are called the increasing vulnerabilities of the family unit, apparently pointing to the dangers of the family, of the recognition of the rights of women, on the one hand, and of same-sex couples and other sexual minorities. In other words, it seems the traditional patriarchal family unit requires protection from challenges to its structure. So there is a sense in these resolutions that protecting the family unit is more important than respecting the human rights of the individuals within the family. And it's been pointed out that this idea that the family is somehow sacrosanct could undermine the claims of women and girls in some parts of the world to equal rights to property and inheritance. Also, we have another strand of work in the Human Rights Council, particularly the work of the Special Rapporteur on Violence Against Women, who have consistently emphasised the family as a site of violence against women, and the way that pathologies of the family can obscure the way pathologies within the family can obscure very serious and deep human rights abuses. This is another part of that debate. And I've just got, you probably can't see this, this is the scoreboard in the Human Rights Council from this year's resolution, the 2017 resolution on protection of the family. And very few references to human rights, but you can just see by the yeses. So the vote got up, and if you just look, I don't know how good your eyesight is, but you'll see that the Like-Minded Group, that this is out of 47 members, you've got 30 voting in favour of this very restrictive resolution. You've got the Western Europe and Others group voting no, and then you have a number of countries who have abstained. And they're all quite interesting, the countries that have abstained. So some with a, like Brazil, with a strong Catholic.
Could you just read out the resolution? I'm sorry.
Well, the resolution is about 3 pages long.
Okay.
And
so that sentence at the top isn't a summary?
Yes, so that's just the title of it. Let me read that out. Protection of the family, role of the family in supporting the protection and promotion of human rights of older persons. So each year it's about protecting different groups within the family, but goes on, yes, at quite some length. But I guess my interest in is how is the family defined. So similar to this and related to this has been the long reluctance of the Council to deal with discrimination on the basis of sexual orientation. So when the Council first held a debate on LGBT rights in 2011, all the members of the Organisation of the Islamic Cooperation walked out. However, since then, there have been resolutions that condemn sexuality-based violence and discrimination. And last year, an independent expert, Thai jurist Vitik Muntaborn, was appointed on this topic. This is the vote, actually, this is now 3 years ago. This was a vote in favour of a resolution recognising the human rights related to sexual orientation. And you can see then, again, it's interesting, so all the Western countries are voting in favour, but if you can see that the abstentions and the noes are almost to half the council there. So this is my overview of the Human Rights Council. You can see that the context into which Australia is about to be launched is complicated. So although I welcome Australia's imminent election for the Council, I do regret that there's going to be no competition or assessment of our human rights record. Indeed, what's striking is that on this occasion, for this election, all regions of the world except Asia have presented so-called clean slates. In other words, they've nominated exactly the number of countries for which there are seats. So it means that countries in which massive human rights violations, including systematic torture, are currently taking place, such as the Democratic Republic of the Congo, will be automatically elected. It will be very interesting to see tonight whether the DRC is elected. They only won't be elected if the majority of the states voting in the election in the General Assembly don't support them. Given the strength of the African bloc, I think that's unlikely, but I may well be proved wrong. There is a campaign by a number of NGOs to try to get countries not to vote against the DRC, but not to vote for their candidacy. I should also note that it's very hard to suspend a council member with the requirement that 2/3 of the General Assembly vote to expel a state that's engaged in gross and systematic violations of human rights. So it leaves current members that overtly reject human rights standards, such as Burundi, the Philippines and Saudi Arabia, relatively safe. Okay, well, Australia and the Council. Our main engagement with the Council over its first 10 years largely has been through the Universal Periodic Review mechanism. And we've been, as I've said, through 2 human rights sessions scrutinising our record. And this is, you can see John Quinn, the Australian ambassador to Geneva there. This is during the second UPR. So countries make recommendations to Australia, and these have largely concerned treatment of asylum seekers, the situation of Aboriginal and Torres Strait Islander peoples, and concerns about multiculturalism and racism. What Australia tends to do is to accept a large number of the recommendations. The first time round we accepted 90% of the recommendations. Then we go very, very vague on implementation. And when we were up in our second UPR, it was pretty clear, although we had apparently accepted 90% of the recommendations that he made, the Australian Human Rights Commission, which assessed this, found that fewer than 10% of the recommendations had been complied with fully. So I noticed when I went through Australia's most recent set of the recommendations it had accepted that what Australia is tending to do, like many countries I should say, is simply to say without any analysis or evidence, our laws and policies already comply with most of these recommendations. So we just have this bland pushback, don't worry, we're complying with it. And there's no serious attempt to review Australian law in a self-critical way. We know also we have had a series of visits by UN special rapporteurs over the past couple of years, and all of them have ended up making recommendations of differing criticality, but some of them have been very tough indeed about the way that Australia is simply failing to observe its obligations, most notably in the area of refugees and asylum seekers, and also in the context of our Indigenous population. So Australia tends to sort of say yes in a bland way, but then either if it gets critical feedback from the UN, it will simply say you don't understand our situation, we do that already, or it will simply reject the findings. So the rejection of Australia always to questions on asylum seekers and treatment of refugees is to simply say we take our security, the security of our borders, absolutely crucially, and it simply posits that as a knockdown response to the human rights criticisms. What's striking, of course, a thing that Gillian Triggs, as President of the Human Rights Commission and since she stepped down, has often made the point a critical thing in Australia is the expansion of executive discretion and the undermining of judicial independence. So we've seen this happening continuously in a whole range of areas, including administrative powers to detain indefinitely various classes of persons, including refugees and asylum seekers and people who've received adverse security assessments. And we saw just in recent days the extraordinary overreach by counter-terrorism laws, which is allowing increasing executive discretion. But when we look at Australia's glossy campaign for election to the Human Rights Council, perhaps you might say unsurprisingly, none of those issues get an airing. Julie Bishop has been very active on Twitter, and we keep saying that the Indo-Pacific region is a particular focus of ours, although it's not yet clear how prepared Australia will be to support human rights campaigns within our neighbourhood. But we've announced that's another, some post-structuralists will be able to do a wonderful study of the images that Australia has used in its human rights campaign. I was very struck by the use of a kangaroo in a human rights campaign, but I suppose it's meant to show us bounding forward. We've said that Australia's campaign is built on 5 pillars. This is a quote from the DFAT document. We've also said we're going to be a strong advocate for abolition of the death penalty globally. We've mentioned equal rights for LGBTI people and freedom of religion and belief. So these are all important issues, of course, but you can tell they're pretty selective. I have, I'm just hoping this will work, a clip which I'll just let run. But if it doesn't work, I recommend it. Again, very interesting, Australia's video for election, which seems to be, if you don't have the sound up, and I'm not letting you hear the sound because you have to listen to me, but it looks like a tourism. There's a certain aspect of it that seems like a tourism, but you can see the number of images of Sydney Harbour is quite striking. Of course, there are people, very serious people like Fiona McLeod, who's here. You'll see some very important people in Australia's protection of human rights. But if you listen to this, there are a couple of images of Indigenous people, but there is no reference at all to, say, the situation of incarceration or health. Anyway, I recommend it to you. It's going to be very interesting to see how consistently Australia pursues its human rights agenda, especially in relation to superpowers such as China, a fellow council member. The Chinese government has been extraordinarily sensitive about criticism from the Human Rights Council detaining members of NGOs who have gone to Geneva to witness the Chinese UPR proceedings. Okay, then to conclude, Australia likes to present itself as a virtuous international citizen, and its candidacy for the Human Rights Council is a sign of this outward engagement. And I think it's fair to observe that Australia has over the years made important contributions to the international human rights system from the time of Dr. Evatt on. And I should also acknowledge that some extraordinary Australians have served within the system. I've already mentioned Philip Alston. We also have people like Elizabeth Evatt, Michael Kirby, Ron McCallum, Ivan Shearer, all member of human rights treaty bodies. Elizabeth Broderick, who was featured there, is currently a member of the Human Rights Council's Working Group on Discrimination Against Women in Law and Practice. So that's, and you can see from all of this, there's a very attractive set of images. But we have to be conscious that this attractive image of engagement is in serious tension with Australia's desultory implementation of its international human rights commitments. It suggests that Australia sees its role primarily as monitoring other countries' human rights performance or going out and giving handouts. That's what human rights is about. Our attitudes, I think, are coloured by a form of exceptionalism, implying that international human rights standards are not relevant for what John Howard once called the gold-plated version of democracy that we enjoy in Australia. Well, I think that sort of approach, we have got a gold-plated version of democracy, and human rights are for all you countries out there that can't quite get your act together. That sort of approach underlies our brushing off of reports by the Human Rights Council's special procedures. It's clear that our ambivalence about the international human rights system is manifested most acutely in the context of asylum seekers and refugees. We should be conscious that this is not a recent issue. From the inception of the UN human rights system in 1945, Australia has consistently attempted to ensure that its restrictive migration policies escape human rights scrutiny. So, sorry, I'm going to deny you the rest of that, but it's easily available on the DFAT website. So this is, of course, Doc Evatt back at the UN signing the Universal Declaration of Human Rights. But while his role is often and properly lauded, we should also remember that our anxiety about keeping the White Australia policy free from international scrutiny influenced Australia's negotiating position at the UN. So we strongly supported what became Article 2.7 of the UN Charter, the explicit statement that the UN is not authorised to intervene in matters which are essentially within the domestic jurisdiction of any state, the words of Article 2.7. So that was, we put those words in to protect our White Australia policy from international scrutiny. And it's really striking how those words, non-intervention in the domestic jurisdiction of any state, have been picked up and embroidered and put onto a global canvas at the Human Rights Council by many, many countries. We can see the legacy of Article 2.7, this idea domestic jurisdiction should be preserved, in the recent legislation in Australia. For example, in the wake of High Court decisions that international obligations under the Refugees Convention, the fact that even if unincorporated, they should shape the interpretation of the Migration Act. We know that the Commonwealth Government has legislated explicitly to allow decision-making that violates international law. So the Minister for Immigration's discretion, exercise of discretion in respect of asylum seekers, is allowed explicitly to be inconsistent with Australia's obligation under the Convention. And now, as we try to extricate ourselves from the detention centres on Manus Island and Nauru, it's becoming increasingly clear how utterly the human rights of the people in those areas have been violated. The UN High Commissioner for Refugees has documented the fact that the detention system on Manus Island, which is depicted here, has produced some of the highest rates of mental health disorders of any surveyed population anywhere. It's 88%, an extraordinary incidence of mental health issues. And I understand that Australia is now, as we speak, winding down all of the support systems, the mental health support systems for the people who are being held in limbo there. But I think despite, or perhaps because of these serious problems, I think as people interested in human rights, we should work to ensure that Australia's membership of the Human Rights Council for the next 3 years is a positive one. Given the undoubted quality of our representatives in Geneva, Australia has the capacity to promote progressive human rights standards and also to insist on consistent application of those standards. It's whether the politicians who guide our gifted diplomats will allow them to do so. So I hope that membership on the Council will, in turn, bring pressure on Australia to take the international human rights system seriously at home, a task that the Castan Centre has always undertaken with great energy and impact.
It's an honour to stand here with Hilary. I don't think I've ever done this before. It's quite a thrill. We have about 15 minutes for questions, so time for perhaps 3 or 4 questions of Hilary. We don't have a microphone, I don't think so. You'll just have to speak.
Oh,
Oh, we do! Lovely. Okay, so there are 2 roving mics. So do we have any questions from the audience? Julie.
Hilary, in your opinion, do you think that a better quality state is being voted into the Human Rights Council because supposedly states have to take into account the human rights record of people that are up for membership, or do you think that's being gotten around by only putting forward the right number of states for the right number of places?
So you're referring to the Clean Slate?
Yes.
Yeah. Oh, well, that's a very good question. I think what you can see if you look at the Clean Slates that's been presented, as I mentioned, I think from especially the African bloc, I think it's much more a challenge to the Human Rights Council. If you put up the DRC, where it's just extremely well documented, the security forces not only, and government sanctioned systematic torture of citizens and enrolment of child soldiers and so on, you're saying, there are many countries in Africa, you're saying something pretty clear. So the African bloc is saying something by putting those up. It's interesting, and I think very heartening, that Asia has decided they're running 6 countries for 4 slots, and I see that as very advantageous. I just say also that this practice of clean slates has attracted a lot of discussion within the council, and earlier this year a Netherlands-led initiative got a lot of countries to sign on saying we won't let there be a clean slate in our bloc because there's always an advantage in having an election. One example of the distinct advantage is in the elections before this, when the Eastern Europe bloc didn't have a clean slate, and Russia, which expected to be re-elected, was actually wasn't elected. So that's pretty powerful if you're electing Russia, and Croatia was elected instead. So it's pretty clear that if you do run a competitive election, there is some capacity to really put pressure or even eject states that have been really trying to work against human rights issues. So I see this as a very disappointing outcome on this election.
Okay, any other questions from the audience? Adam?
Thank you very much, Hilary. I was wondering, with your experience over the last couple of decades of Australia's official statements on human rights and responses to the Committee and Council, have you detected any sort of shift over, say, the last 20 years in the rhetoric or the attitude, or would you say that it's been fairly consistent?
I think Australia is becoming more sophisticated in its rhetoric. I think that, and this, I think it's probably 30 years that I've been keeping an eye on these things, and you can see that sometimes we engaged in perhaps more direct, this is simply not a matter of international concern. But as I was suggesting, our practice of, in the Universal Periodic Review, realising it's not going to be a good look if we reject a whole range of recommendations. I think that what we're doing, Australia is not alone in this, but realising that it's perhaps easier to pay lip service to the standards and then just say, yes, we accepted them, but we did so in the knowledge that our perfect gold-plated legal system has already got those absolutely sorted. So I think there has been perhaps more sophistication in developing these ritualistic forms of compliance. But you also have, I would say, on the more positive side, I think it's as you've perhaps got a greater understanding of the human rights system and perhaps a greater willingness to take on issues. So I think Australia taking on, I mean, it is ironic in light of the postal survey that, you know, we're seen as a bit of a champion at the international level on LGBTI issues, and yet it doesn't quite seem that within Australia. I would also say there are other things that we do that I don't understand. So I was very struck by the fact that recently Australia was criticised by the Committee on Economic, Social and Cultural Rights when we presented our report under that treaty earlier this year. The committee pointed out that Australia's core document, that is the basic document you attach, was 10 years old. So here is Australia with all of its resources presenting in 2017 a 10-year-old document, which just seems almost, is it oversight? Is it, you cannot imagine a government going to a UN body with a 10-year-old document and saying, here, take this. It does suggest, unless there may be some other explanation, but it does seem a certain either apathy or insouciance about scrutiny by the Human Rights Treaty bodies. So I think there's been a regression in that respect.
Thank you.
Economic, social, cultural rights require progressive realisation, so perhaps
Yes.
the progression was thought to be extremely
Really
slow. We have a question just there.
Thank you very much. My name is Lyndall Rollins. I'm a freelance journalist and also a UN correspondent. The campaign is almost over, and I'm wondering if you think that once Australia is elected, there will be any opportunity for further scrutiny of Australia's Human Rights Council, Australia's Human Rights record from civil society once we are a member. In one particular issue that I'm interested in is actually Australia's role in extractives overseas, and whether Australia being on the council will lead to any more scrutiny in general, but also in that issue in particular. Thank you.
Yes, thank you. Thanks for that question. Look, I think we don't know at the moment. I mean, on the one hand, Australia, I'm sure on some issues it will be very active, and I want to sort of acknowledge that it's not as though it will be a waste of time, or that Australia will use all of its energy in covering up human rights issues at home. I don't think it will do that. But we do know from observers of Australia at the international level often point out that we tend to be inconsistent on the countries that we criticise. If there is a direct interest in a particular country, we will be quite reluctant to criticise. We've tended to focus, if you look at the statements that the current government has made criticising human rights abuses in other parts of the world, they are just a particular set of countries. We tend to be pretty protective of what Australian corporations are doing abroad, as many countries are, but Australia is particularly sensitive to these issues. So it's sort of going to be quite interesting. The United States is currently a member of the Human Rights Council. You can serve 2 consecutive terms and then you have to go off it. But the United States is currently there, and it's been interesting that will Australia follow the United States lead on human rights issues is the question, because we can see under the Trump administration that the United States has been espousing more conservative causes, and it'll be very interesting to see whether Australia will part company with its great ally, as we're so often reminded. So I hope, the optimistic side of me hopes that for Australia to play a very active role, as it will, as a member of the Council in other countries' universal periodic reviews. It'll be directly involved in the committees that monitor these. Perhaps there might be some sense of wanting to clean up its own house, but we have shown, I think, a remarkably thick skin so far with respect to holding some human rights issues up to the light and other ones just really absolutely pushing under the carpet. So I think this is where civil society has a very important role, and I'm actually hoping that Australia's election to the Human Rights Council will be an important resource, an important lever for not only civil society in Australia that's already very well organised and active, but civil societies in other countries, thinking of countries where we, such as Nauru and PNG, whose territory we're using effectively at the moment to perpetrate quite significant and human rights abuses, hoping that it will empower groups there.
Unless you have a very, very quick question, I'd like you to join me in thanking Hilary, because we are... Thanks so much, Hilary, and thanks everyone for coming.